Hello everyone, a very good afternoon, a very good evening to all of you. Welcome to the Officer Adda channel of Adda 24/7. A very warm good evening. So today we are going to start the mini marathon, and today we are going to start the mini marathon of the module D. So this is very much important for the examination point of view, as we know that in your exam C and D module of Brbl subject is very much important. Its score 70% marks come from C and D. So that's why this is very much important. Okay. Now let's start the session with a first question, that is your paragraph based question. As we know that in the Brbl question, your one-liner question, paragraph based question, it's a case studies question, act year, so many questions are asked, so that's why this is very much important. Okay, now let's start with the paragraph based question. The paragraph is as follows. See, an agreement between two and more party that is enforceable by law is a contract. So class, this is basically the definition of what contract. So we know that the definition of contract is offer plus acceptance is equal to promise. Promise in legal term is called agreement plus law enforceability is equal to contract. So this is a very simple definition of the term contract. Okay, we have already done in the paid class also. So this is the definition of contract. So in India, contract is governed by Indian Contract Act 1872. Okay, in Indian Contract Act, as we can see that in India, the contract is governed by Indian Contract, which is statute containing the detailed provision of the various aspects of contract, including execution and enforcement. The various provision contained in section 2H. So class, in section 2H, the definition of the contract is given. So what is the definition? The definition of contract say that an agreement enforceable by law is called contract. So this is the agreement. It is enforceable by law, that is called contract. So same definition is written here. So agreement is necessary to form any contract. This is but obvious. This is but obvious class. If we are saying the contract, so contract comes from the agreement. So when agreement will come, then contract will come into existence. Okay. Now, section 2E. There are so many sections. First of all, section 2H, section 2E. Okay. First of all, I will highlight the section 2C, section 2A, okay, section 6, that's it. So there are these sections, okay, given here. Now class, section 2E defined agreement. What is agreement? Every promise, every set of promises forming the consideration for each other, it is called agreement. That is a legal definition, okay. The formation of agreement take place when offer is made by one party. See the formula. Offer is made by one party, accepted by other. Under Indian Contract Act, and offer is termed as proposal. Offer is also called proposal class. If there is a no proposal at all, and if a proposal has been made but not accepted, the agreement does not come into existence. Indian Contract Act regulate the various aspects of offer acceptance, such as the manner of making offer acceptance. When communication of offer acceptance get completed, it is called the valid acceptance. Suppose if Nikkita Ma'am is offering you and you are just accepting, so this is called offer is accepted, then it's become an agreement. In agreement, when the law will enforce, it is equal to contract. So that is a very simple definition of the term contract. Okay, so I hope so that is clear. So in this particular, we can see that two terms are there. The first is the definition of contract is given here, and then agreement is there. Then agreement is there. Okay, contract plus agreement is there in this particular. Any doubt class? Any doubt? That is important. Any doubt? Done? So this is your simple definition of agreement and contract. Okay, now let's start with the next one. Section 2A. What is this? Section 2A define the proposal. Okay, it's a definition of proposal. Proposal means offer. When one person signifies to another his willingness to do and to abstain from doing anything with a view to obtaining the assent of other, such act and absent is called proposal. So this is the definition of proposal, section 2A. That is again important one. Section A again class, that is an important definition. Okay, so thus offer, proposal essentially indicate person willingness to do some act or abstain. Abstain means not to do. Okay, see, so offer must be the final willingness of the person. If suppose if I am just questioning and the another person is answering, that is not called the offer. Offer means I'm just putting my final willingness that I just want to sell this car. If you are accepting, that is called contract. Is that okay? So this is the simple definition. Then class, then after section 2C. Section 2C denotes any person making proposal is called promiser. See, this is the definition of what? Promiser. So any person making proposal is called promiser. Section 3 explain how offer proposal can be made. Okay, so there are so many definitions, but no need to learn the definition, just focus on the content. It states that a party may communicate a proposal. A party may communicate a proposal by doing any act, omission, by which he and she intend to communicate such proposal and which has the effect of communicating it. Section 4 explain when the communication of proposal offer gets completed. When the communication offer gets completed. Okay, section 4. So again class, section 4 is there. Okay, communication of proposal is completed when the proposal come to the knowledge of person to whom it is made. Suppose if Nikkita Ma'am want to sell the car, I will just put my offer. When the offer is get into the knowledge of the opposite person, then my offer will be complete. So this is the when the communication of offer is complete. Okay, now Indian contract permits revocation of offer and proposal. So you can also revoke the offer. Okay, section 6 describe proposal can be revoked in the following ways: by giving notice of revocation to the concerned party. If we give revocation notice, it can be finished. By the lapse of time. Okay, by failure of acceptor to fulfill the condition, by death or insanity. So it is important note that offer is different from invitation to offer. Offer means whatever I'm offering. Invitation means suppose the sale is going on. So sale is what? Sale is invitation to offer. That's it. Okay. So this is your particular definition. Now let's start with the question. If A, now see the question. Question is, if A goes to stationery shop, pick up a pen and place a note of ₹10 in front of the shopkeeper while pointing to the pen and holding it up in his own hand without saying anything, A's conduct may be interpreted. It means to explain means A has made dash to the purchase the pen from the shopkeeper. So whether it is promise, invitation, contract or offer, tell me. What is the right answer? Yes, class. A very important question. If A goes to stationery shop, pick up a pen and place a note in 10 in front of the shopkeeper while pointing of the pen. So what is this? A's conduct may be interpreted, that is explained to mean that A has made dash to the purchase the pen from shopkeeper for ₹10. What is the right answer? So class, here it is called A has made an what? It's a offer. This is the right answer. Okay, A has made an offer. Okay, it is not invitation to offer. If the shopkeeper will sell now, then it is called invitation to offer. Okay, this is the right answer. Next, A send letter by post to B containing offer. The communication of such offer shall get completed only when the letter has been received and read by B. Why it is so? Tell me. If A send a letter by post to B containing an offer and the communication of such offer get completed only when the letter has been received and read by B, why it is so? So class, in this question, the offer has not come to the knowledge of B. If it is receive and read, it is the right answer. This is wrong. Letter was illegible. It is undesirable. B has no reason to accept the offer. I think none of the statement is the right answer. Because A send letter by post to B containing offer, the communication of offer gets completed only when the letter is received and read by B. Because no option is correct. Okay, no option is correct in this question. Okay, next. A made offer to B. Before accepting the offer, B find out that A is clinically proved insane person. What shall happen to the offer? That is good question. That is good question, class. Tell me. That is good question. So class, in this one, the offer will get revoked. C is the right answer. C is the right answer for this question. Okay, C is the right answer for this question. Okay, C is the right answer. Next. The display of goods by shopkeeper is called what? Invitation to make offer, a contract, proposal, or sale. What is the right answer? The display of goods by shopkeeper in his shop is what? So this is class basically an invitation to offer. A is the right answer. Okay, next. According to the passage, what does proposal become promise? When proposal become promise? Is the offer plus what is equal to promise? This is the question. Offer plus what? So class, for this one, the right answer will be, that is it when it is accepted. So this is the right answer. Fifth one, B is the right answer for this question. Okay, when it is accepted, then it will be called as this. Okay, now next question, class. What is the significance of the statement that all agreement are not necessary contract? What it signify? What it signify, class? All agreement may not necessarily contract. What is this? Contract are always agreement. Agreement are always contract. Some agreement may lack enforceability and contract do not require the free consent. What is the right statement for this question? Tell me, class. All agreement are not necessarily contract. What is the right answer? Hanji, class. All agreement are not necessarily contract. What is the right answer? All agreement. some agreement class may lack enforceability, because if we say, suppose if a social agreement is there, if a religious agreement is there, so in that case it cannot be converted into the contract. So that's why some agreement means these are the agreement which lack the enforceability. So that's why all agreement are not necessary contract. Is that okay? If we are saying contract, it's come from the agreement. Okay, next. What is the legal status of agreement not enforceable by law? The agreement which is not enforceable by law, it is called what? It is called voidable, void, enforceable, or irrelevant class. Tell me. What is the right answer for this question? The legal status of agreement not enforceable by law, it is called what? Agreement not enforceable by law, it is called void one. So this is the right answer. Voidable, when one party have option to breach the contract. Void, enforceable, irrelevant. Okay, next. According to section 11, who is considered legally competent to contract? Okay, every person who is citizen, every person who is the age of majority, of sound mind, not disqualified by law, and every person who have capacity to perform the impossible task, or every person who is wealthy. Tell me the right answer. Tell me the right answer for this question. Who consider the legally competent to contract? The legally competent to contract, person of majority, sound mind, not disqualified by law. B is the right answer. B is the right answer for this question. Okay, next one. In the case of Mohari Bibi versus Dharmodash case, that is the landmark case in which it was held, any agreement which is done by the minor is void ab initio. Okay. So in the case of Mohari Bibi versus Dharmodash Ghosh case, what did minor do to secure the borrowed sum? Gave a mortgage of certain immovable property, paid in cash, sign a promissory note, transfer ownership of a vehicle. What is the right answer? In the case of Mohari Bibi versus Dharmodash Ghosh, what did the minor do to secure the borrowed sum? Because minor have done the mistake. Minor have done the mistake. So what did he do? If you remember the case is very much important for the examination point of view also. So class, in that case, he just gave a mortgage in the certain immovable property. So A is the right answer for this question. Okay, that's cool. Next. In the context of hiring the safe deposit locker, what is the relationship between bank and customer? Suppose if Nikkita Ma'am is giving jewelry to the bank. So what is the relationship between the bank and the customer? Whether it is trustee and beneficiary, whether it is debtor and creditor, and whether it is bailey bailer or lessor and lessee. What is the right answer? Tell me, class. What is the right answer? So class, the right answer is if a customer is depositing something in the locker, so I'm giving the possession, not the ownership. So that's why the bank is lesser and the customer is lessee, because bank is giving the possession. So this is the right answer. Okay, next. What is contract of indemnity? See class, as we know that in the Indian Contract Act, two parties are two basic thing: general principle of contract, special principle of contract. General principle of contract, offer plus acceptance is equal to promise in legal term agreement plus law enforcement is equal to contract. That is a basic formula of contract. Special principle of contract, in which we have to study indemnity, guarantee, bailment, pledge and agency. So tell me class, what is contract of indemnity? A contract where one party promises to cause harm to the other. The contract by which one party promises to save the other from the potential loss. A contract where both parties agree to share loss equally, and the contract slowly based on the mutual consent. What is the right answer? What is the right answer for this question? So class, contract of indemnity. This is wrong. So class, for the 11th one, the right answer is B. B is the right answer for this question. Is that okay class? B is the right answer for this question, okay? Because it's a contract by which one party promises to save the other from the potential loss. So that's why for the 11th one, B is the right answer, okay? You just tick mark on the B. According to section 125, section 125 is very important. Let's talk about right of indemnity holder. Section 25 talks about right of indemnity holder. A short form to learn, CDS. For all cost, for all damages, for all sum, the indemnity holder can take money from the indemnifier. So indemnity, all the insurance are the example of contract of indemnity except life insurance. Okay, indemnifier who promises, indemnity holder and indemnified are the same party who are just for the protection of loss. Okay, so class, according to 12 of section 125 of the act, what damages is the promise entitled to recover from the indemnifier in a suit related to promise to indemnity? What is the right answer? Tell me. Only direct damage, all damages compelled to pay, damage proportional to indemnified income, or damages limited to the amount specified in this one? What is the right answer? Tell me class. Section 125. A way to learn section 125 is CDS. CDS. Cost, damages, this. So B is the right answer for this question. Okay. Now, this is very important class, very important part. In Praful Kumar Mohanty versus Oriental Insurance Company Limited, what did insurance policy require regarding the notice in the event of theft of any criminal act? I hope so you people remember this case. In this case, it was held that, a bike was theft, so he immediately informed the police. But after 1 month, he just informed the insurance policy company. So it was just in the court, it was held that if the person is immediately informed the police, it means that person is in good faith. Okay, the person is in good faith. So tell me, in this case, what did insurance policy require regarding the notice in the event of theft or any other criminal act? Notice within 12-24 hours. Notice as soon as insured remembered. notice immediately to the police, or notice given with the promptitude? What is the right answer? What is the right answer for this question? Praful Kumar Mohanty versus Oriental Insurance Company Limited. What is the right answer? So class, the right answer is notice immediately to the police that show that the person is the right person. That show that the person is the right person here. Is that okay? Just a minute, class. Okay, so this is the right answer. Done, class? So C is the right answer. Next, according to section 148 of Indian Contract, what is the legal definition of term bailment? Exchange of goods for services, delivery of goods for a specific purpose under the contract, the sale of goods between two parties, and the gift of goods without any contract. So what is the right answer of the contract of bailment? Contract of bailment, class, what is the right answer? Because the 5 terms are very, very much important. And in today's module B, we will cover all the questions class. So bailment means, suppose if Nikkita Ma'am have given suit to the tailor, so I can just take back my suit. So that's why the right answer is delivery of goods for a purpose of under the contract. So 14th one, B is the right answer. Okay, next. What is the consequence if agent put himself in a position where interest and duty conflict according to the formation provided? The agent is exempt from any consequence. The principal has no recourse against agent. The contract can be rescinded by the principal. Agent is entitled to the additional compensation. What is the right answer, class? Tell me. What is the consequence if agent put himself in a position, okay, where interest and duty of the principal and agent is conflict? So class, in this case, the contract can be rescinded by the principal because agent have to work according to the direction which is given by the principal. So agent have no right to work anything in which the decision or the things are contrast with the principal. Okay, now next, how the contract for the sale of goods govern? How the contract for the sale of goods govern? Exclusively by sale of good, exclusively by contract act, by both sale of goods and contract act, or by IPC. See, as we know that Indian Contract Act, 2 acts has been removed from Indian contract. The first is Sales of Good Act and then the Partnership Act. So these 2 acts were the part of the Indian contract, but it was removed. In the Indian Partnership Act come into picture in 1932 and Sales of Good Act in 1930. Okay, now tell me, how the contract for sale of goods governed? So class, the right answer is C is the right answer for this question. Okay, C is the right answer for this question. Okay, now, what is implied warranty related to the charge or encumbrance in the contract of sale? The buyer is responsible for any charge or encumbrance. The goods shall be free from any charge or encumbrance in the favor of any third party. The seller is responsible for any charge or encumbrance. The charge, encumbrance are optional, may be present. what is implied warranty? So class, there are two types of things. The first is warranty and the second is condition. Condition is basically called guarantee. In warranty, we can just replace the things, but in condition, we can just refund, and the second one is refund and we can just demand for the new, or we can just breach the contract. Okay, now tell me, what is implied warranty related to the charges and encumbrance in a contract of sale? The buyer is responsible for any charge or encumbrance. The goods shall be free from any charge, encumbrance in the favor of third party. So class, it is implied. Implied means that is not written, because there are two types of things, express and implied. Implied means by the way of act and conduct. Express means written oral. Okay. So implied warranty is basically the goods shall be free from any charge, encumbrance in the favor of any third party. So B is the right answer. Okay. Now, according to the doctrine of caveat emptor, what is a buyer responsibility when purchasing the good? There are two legal maxims. The first is caveat emptor. The second is caveat venditor. Okay. Caveat emptor, let the buyer be aware, and caveat venditor, let the seller be aware. Let the seller be aware. What is the right thing? Tell me. Rely slowly on the seller statement. Keep eyes closed and mind inactive. Be cautious, keep eyes open and examine the goods thoroughly, and blame the seller for any issue with the goods. So class, for this one, the right answer is C is the right answer for this question. Is that okay? Now, next one. What are the rights of unpaid seller against buyer personally as per the information provided? So we know that class, for the unpaid seller, the right will be unpaid seller. The right will be basically of against the buyer and against the goods. Okay, so these are the rights of unpaid seller. So what are the rights of unpaid seller against the buyer personally as the information provided? Right to demand possession of goods, right to cancel the contract, right to claim damages, price of the good with interest, repudiate the contract. So as we know that, this C will be the right answer for this question. Is that okay? The questions are very much easy. That's totally depend upon your concept. Okay, next one. How the partnership at will be dissolved? There are three kinds of partnership class. The first is partnership at will. The second is particular partnership. It's a particular partnership. And the next is partnership at will, particular partnership, and fixed time partnership. Fixed time partnership. Okay. So partnership at will, what is the right answer? By any partner giving oral notice, by any partner giving notice in writing to the some partner, by any partner giving giving notice in writing to all other partner, or by mutual agreement. So class, here the right answer will be this. C is the right answer. Okay, to all the partners we have to contact. How the partner can make the firm liable for his act? As we know that if we go through the concept of partnership act, if one partner is doing any act, for that act all the partners are liable. Okay, so when a partner make a firm liable for his act, only in extraordinary circumstances, if done in the name of firm in the ordinary course of business, if only if explicitly authorized by other partner, or if the act are done in the partner's personal capacity. What is the right answer? When a partner make firm liable for his act only in extraordinary circumstance, if done in the name of firm in the ordinary course of business, only if explicitly authorized by other partner if the act done in the partner's personal capacity. This is the right answer. B is the right answer. Always B will be the right answer. Okay, next. When the person who was minor elect to become a partner, what are the right and liabilities? When a partner who was minor elect to become a partner, because we know that, see, the minor cannot become a partner, but suppose if minor become a partner, so after attaining the majority, he have an option. Within 6 months, he have to declare whether he want to become a partner or not partner. So he have an option. So suppose minor elect to become a partner. So what it is right and liabilities? Right and liabilities as minor continue and he is not liable to the third party. Right and liabilities as a minor continue but he becomes personally liable to the third party. No right and liabilities continue and he only becomes liable for the act of the firm after becoming a partner. What is the right answer? This is very important question. This is the wrong one. This is wrong. Right and liabilities as minor continue, but he becomes personally liable to third party for the act since admission. This is the right answer. B is the right answer. Okay, B is the right answer for this question, since from the admission, the minor, when he becomes the major, can become the liable. Okay, next. Who were the subscriber to the memorandum of association with when Solomon incorporated a company? This is a very landmark case. So as we know that according to the Company Act, the company have a separate legal existence and the member have a separate legal existence. Okay. So in this case, who were the subscriber to the memorandum of association? It is Solomon and his wife. Solomon, his wife and 5 children. Solomon, his wife and 4 sons and the daughter. Solomon, his 4 sons. What is the right answer? If you know the fact, you can easily do the question. If you know the fact, you can easily do the question, class. What is the right answer? Who were the subscriber to the memorandum of this? So class, this C is the right answer because that is written in the fact. Okay, next. When the term used for document that regulate the internal management and procedure, what it's called? Memorandum of association, certificate of incorporation, article of association and partnership deed. What is the right answer? That is good question. The term used for the document that regulate the internal management. So as we know that there are 2 types of document. The first is memorandum of association. Second is article of association. Memorandum of association, that's talk about the relationship between the outside person with a company, and article of association, that's talk about this one. So the term used for the document that's regulate the internal management and procedure of a company, that is called article of association. Okay, partnership deed, that is an important document of partnership form. Okay, and for the LLP class, the important document is called LLP agreement. So you have to learn everything, every point of this part. Okay, next. According to section 3 of LLP, what define LLP a legal status? Tell me, class. It is a partnership recognized by the Partnership Act 1932. It is a body corporate form and incorporated under LLP Act separate from its partner. It is the extension of personal identity of its partner, and it is a legal entity formed under the Company Act 2013. What is the right answer? So class, according to section 3 of LLP Act, the LLP, a legal status, if we say, yeah, it is a body corporate formed and incorporated under LLP Act and separate from its partner. So B is the right answer. Okay, next. How does LLP agreement contribute the flexibility and adaptability of the partnership structure? It provides fixed and unchangeable framework. It allows changes only with the approval of registrar. It allows partner to modify rights and duty. It imposes rigid restriction on the partner interaction. What is the right answer? So class, as we know that in LLP agreement is an important thing. So it allow partners to modify the right and duties needed. So 26C is the right answer for this question. In LLP agreement is the important document. Okay, now what type of mortgage? This is very important part class. In section 5 clause B is C class. Section 558 clause A define the definition of mortgage. Section 58 clause B of TB Act, where the mortgagor does not deliver the possession of property, what it called? It's a hypothecation mortgage, pledged mortgage, simple mortgage or equitable mortgage. Tell me the right answer for this question. So class, for this one, the right answer is simple mortgage. Equitable mortgage is the only mortgage where no need to require the registration. No registration is required in the equitable mortgage. Okay. Now, are public sector bank and institution owned and controlled by government considered public authority under RTI? Yes, only bank, only institution, yeah, both. As we know that under RTI, we can just ask any information from the public authority. Okay, so tell me the right answer for this question. Are public sector bank institution owned and controlled by the government consider the public authority under Right to Information Act 2005? Say yes or no. The answer is yes, both this one. Next. If information under RTI concern life and liberty, how quickly it is provided? Within 24 hours, 48 hours, 72 hours, 30 days. What is the right answer? In the normal, if we ask any question, within 30 days, information should be given. And if we talk about the life and liberty, so within how many? This one. That is important question. So class, for this one, the right answer will be within 48 hours. This is the right answer. Which act amended when IT Act come into picture? Tell me class. IPC, Indian Evidence Act, Bankers Book Evidence, Company Act, NI Act or Factory Act? This is again important question. Which act has been amended when IT Act come into picture class? Tell me. So class, the right answer will be A is the right answer for this question. Which one? A is the right answer for this question. This act has been amended. Okay, that's good. Next. How many years does the judge have conclude the trial, including any extended period, according to the Prevention of Corruption Act? This is very important question. The Prevention of Corruption Act has been introduced. Okay. Yes, class, tell me, what is the right answer? For this question, how many years? The right answer is, that is 4 years. Minimum 2, at a time 6 months, up to 4 months, 4 years. Okay. Now, what is the significance of Prevention of Corruption Act in relation to the public servant and other in the country class? Tell me. Again, important question. So class, for this one, the right answer will be to curb the corruption and the public servant and others. So C is the right answer. So class, that's all for today's class. So this is your mini marathon of module B, in which we have covered all the acts. So module D contain total 9 acts, which is very important for the examination point of view. And class, we have a English medium crash course. My subject is going to be start from 11th of November. The timing will be 10 to 11 p.m. So if you want to enroll in the batch, you have to apply the coupon code Y391 for the maximum discount up to 80%. Okay. So apply the coupon code. You can also purchase the single batch, video courses, ebooks, books and Mahapack. So in Mahapack, DV is going on. So if you purchase the CAIIB Mahapack, you will get all the live classes till now in English and bilingual language. You will get marathon and mini marathon session of this particular CAIIB. You will get elective paper recorded courses, and before exam we will also launch the revision batch of elective paper. You will also get the live classes and everything whatever you want. So if you want to enroll in the CAIIB ka Mahapack also, apply the coupon code Y391 for the maximum discount. Is that okay? So again I will say, at every Saturday at 9 p.m. this is your module B. Next Saturday 9 p.m. we will conduct module C, after module B, and after that module A. So this is the complete mini marathon, and before exam we have a 1 week of time. So in 1 week we will do the revision batch, and we will also do the important YouTube session, just like the compilation YouTube of summary session, compilation of definition terms, compilation of the penalties, then limitations, appeal in one video, etc. So if you want to see every session, please follow the YT session and do not subscribe this JIB CAIIB English Medium channel. Myself, Nikkita, if you have any doubt, you can please ask in a comment box also. Thank you so much for attending the session class.